The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Monday, the 4th of April, 2016 are currently trading with gold at $1,215.51 an ounce, silver $14.96 an ounce, Texas crude $36.79 a barrel, and Bitcoin is currently sitting at about 418 U.S. currency. Today in history, the year 1968. African-American U.S. civil rights activist and minister Martin Luther King Jr. is assassinated in Memphis, Tennessee. He was shot while standing on the balcony at the Lorraine Motel where he and his team of civil rights activists were staying at. A circuit court of Shelby County, Tennessee, 13th Judicial District at Memphis in December of 1999 found that unspecified U.S. government agencies were complicit and guilty in the assassination. Dr. Martin Luther King Jr. was shot and pronounced dead. Today in history. In recent news, New York Democratic Senator Charles Schumer called on the Federal Department of Justice and the Bureau of Alcohol, Tobacco, Firearms, and Explosives to investigate a gun that appeared to look like an iPhone. The manufacturer, Ideal Conceal, said that the government's concern over the weapon is misplaced. CEO Kirk Gilberg said that the gun is expected to be ready for market later in the year. Images of the weapon on the company's Facebook page show what appears to be a regular smartphone case. However, it's just not any case since this one opens up into a .38 caliber handgun. List price is expected to be around $395 US. Gilberg, who has a concealed carry license himself, says he came up with the idea for the gun after a young child in a restaurant caught a glimpse of his more obvious weapon and pointed it out in public. Schumer's arguing that the gun, which appears like an everyday item, could violate federal law, which is why he requested today that the Justice Department and the ATF investigate. A small fire today forced the evacuation of the Internal Revenue Service's headquarters in Washington, D.C. Apparently, the building was closed around 2:45 in the afternoon due to electrical issues concerning the heating and air conditioning systems. Of the 2,000 people or so who worked in the building, many had already left before the fire started around 3:30 when it was reported. The small fire, which was apparently contained to only one room in the basement, was in fact related to electrical issues, though the direct cause is still under investigation. Luckily, the IRS assured the public that tax returns are not processed at this particular building and will thus have no effect on tax return processing. There were no reported injuries. This is Rick Rohde with your lowdown for April 4th, 2016.
You gonna do? Yeah. Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? When you were 8 and you had bad traits, you go to school and learn the golden rule. So why are you acting like a bloody fool? If you get hot, then you must get cool. Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do?
Okay, howdy. This is Randy Kelton, Deborah Stevens, Rule of Law Radio on this Thursday, the 7th day of April, 2016. Well, I'm going to turn the phones on. We keep the phones on all night. I have Jeff from Mississippi. Just a little bit. I was down in Weatherford in Parker County. And surprisingly, just from the show, I've got 2 or 3 different people from Parker County called me about the horrendous crap they're pulling in Parker County. So I went down there today and only got threatened to be with arrest once. So that was pretty good in the overall scheme of things. But we still haven't got the problem fixed because these guys absolutely feel like the law simply does not apply to them. If we've got one caller, so I'll take that. If we don't have a caller after that, I'll go into what went on in Parker County today. Okay, we got Jeff from Mississippi. Hello, Mr. Jeff.
Hi, Randy.
How are you today?
Well, I got some really, really strange news. The one of the parties that I'm suing in my Title 42 1983 suit has answered my complaint and is accusing me of not servicing her process serving correctly. That it has been done incorrect. So I called the clerk, and the clerk did not have a straight answer because the marshal has not sent the receipt that service was processed. but that the clerk thinks that the woman got served because she's answering in the beginning.
That was what I was going to say. So what? The only time that's relevant is in the matter of objecting to a no answer default.
Oh.
How were you? Okay, you weren't served properly, so how were you harmed? Do you not have constructive notice that there was a suit? It seems like you did because you answered it. So what's your problem?
Okay, now can I move against her in this case because of a fraudulent statement?
Well, Bargreave, their attorney, for filing the stupid pleading.
Oh, okay. I can't move for summary judgment based on...
Oh, yeah, you can, but the judge... you got a judge up here, and you got these two parties bickering back and forth over minor nothingness. Since you're pro se, probably what you could do is dismiss that in passing as irrelevant, as she obviously filed the suit, so therefore she had constructive notice. Since we haven't moved for default judgment, for no answer default, the complaint about notice is irrelevant, and just go on. If you do anything, then Bargreave's the lawyer for filing it. But leave the judge out of it. All he'll do is get annoyed at both of you.
Oh, okay. Okay.
And it'll make you sound more professional.
Okay. I got it. Okay. I think that is the...
How complete was their answer?
Well, their answers are very, very incomplete. Every item is either it's just denied and it doesn't have an explanation. In the case where they said that service of process was incomplete, that's all they said. That the defendant, plaintiff's claims are insufficient due to insufficient service of process. And then it just goes on.
What were the other... I'm trying to get at if the answer is sufficient. If the answer doesn't adequately respond, then you move for default judgment.
Oh, really? Okay, well, then all of their answers are basically defendant denies plaintiff's allegation in paragraph 1. Then plaintiff denies plaintiff's allegation in paragraph 2. And it just moves on and on and on. Finally, with the service of process, plaintiff denies that any complaint from, or defendant denies any complaint from plaintiff due to insufficient process of service. And then it just moves on. That's the whole thing. Nobody...
Okay, I have to go back and look. In some... Okay, you're filed in the Fed. I think in the Fed they have to answer the accusations with particularity. And you can move for summary judgment based on insufficient answer. The simple recitation of the statement that you deny the allegation without specifics as to why you deny the allegation should be insufficient. You should move for summary judgment.
That's what I want to hear. I'm going to jump on that.
Do the research on it. I haven't researched that directly. It's been a long time since I've looked at it because I had the claim against me one time, and it's been so long I don't remember how we addressed that.
Okay. I will research that and get on it. That is my only question that I had. It was just such of a weird thing that I wanted to jump on it.
Well, it sounds like they didn't have much of an argument because they may be concerned because you're pro se. Have you filed any grievances against them yet?
Oh, yeah, everybody. I've filed bar claims against everybody from here to Pittsburgh.
That may be the problem. They may be afraid to try to make some horse manure claim because they may be afraid you'll come back after them for it.
Well, okay, here is something I had to actually shuffle through. On 2 or 3 of their arguments, they do cite case law. In one case, they are citing the Rooker-Feldman doctrine, that I can't sue because of that, and then I can't sue because of the Heck doctrine. Well, I looked both of those up, and that's absolute rubbish.
Heck doctrine.
Yep,
Explain in the Heck doctrine.
Well, one or the other, I'm getting them mixed up. One of them is Fruit of the Poison Tree. And in one case, a policeman jumped on a person and beat him up, and then the person defended himself, and then so he beat the cop up. And so in one of these doctrines, they were saying that, well, the assault could have been due to unlawful arrest and vice versa, that one had to do with the other. And then the other doctrine had to do with someone trying to sue somebody twice. It's not collateral estoppel, but it's almost
that's a pleading. That's double jeopardy.
Yeah. And so, and either way, I trampled all over them. I said that that the opposing party violated the law clearly, and I even listed the law that she broke. So in this case, their arguments were completely rubbish, and I would like to jump all over them.
Okay, have you looked up the Heck Doctrine? I'm looking it up now. Okay, favorable termination after freedom. Why Heck's Doctrine should reign within reason. It looks like the Heck Doctrine goes to a 1983 suit. An alleged violation of an individual's legal rights demands an opportunity for redress. There can be no more equitable position than this for right and remedy to go hand in hand. In a democratic society, however, the availability and scope of a remedy is always commensurate with the value society places on the right at stake. The significant value of the American people place on protecting their rights is reflected in 42 U.S. Code 1983. The statute provides litigants an avenue by which they may pursue a civil remedy against actors who, under color of state law, violate their federal rights. The United States Supreme Court has described the purpose of 1983 as interposing the federal courts between the states and the people as guardians of the people's federal rights. Section 83 creates a species of tort liability to address this end. A particular problem situation may arise, however, when a 1983 plaintiff has a criminal conviction that has never been invalidated. Consider a scenario imagined by Justice Scalia. An individual is convicted of resisting arrest and sentenced to time in jail. His conviction is not overturned on appeal through habeas. He subsequently files a 1983 action against the officer who arrested him, claiming his Fourth Amendment right to be free from unreasonable seizures was violated. In the underlying criminal trial, the state carried its burden and demonstrated the individual intentionally prevented a peace officer from effecting lawful arrest. If the plaintiff were to succeed on his 1983 claim, he would have to demonstrate that his arrest was unlawful. This showing would necessarily imply the invalidity of the underlying conviction or sentence. The possibility then arises that two judicial decisions could reach diametrically opposed results regarding the same set of operative facts if such a collaterally attacking 1983 claim was cognizable. If the true purpose of 83 is to interpose the federal courts, however, the significance in finding collaterally attacking 1983 claims non-cognizable is magnified when the plaintiff is ineligible for federal habeas corpus relief and has no other access to the federal courts. Unfortunately, the Supreme Court has not settled the issue of whether a collaterally attacking 1983 claim brought by a non-habeas eligible plaintiff is cognizable. As a result, the Circuit Court of Appeals are split as to the proper course of action, with non-habeas eligible plaintiffs having the chance to succeed on their claims, while others are categorically denied that opportunity. If this is addressing, here we go. Part of this comment outlines the dictum opinions of the Supreme Court on the issues in Heck v. Humphrey and examines the manner in which the federal circuit courts have interpreted and applied these cases. This will take too long to get to all of it. It gets to Heck. Okay, in Heck, the justices, let's see where I'm at. I'm out of time. Hang on, Randy Kelton, Rule of Law Radio. We'll be right back.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Politically and them getting mad and angry, but them not standing up and fight. slavery and get handbook from the government. We ask the question. Don't have the answer. We ask the question. And they don't have the answer.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Jeff in Mississippi, and we have Jeff from Maryland that wanted to comment on Jeff's issue. Go ahead, Jeff.
Okay, a couple of things. I do believe last week, Jeff, that I had strongly suggested to you that you sheathe those claws of yours. And yet, first thing out of the bag on this call, I hear you, I want to get them. And I'm telling you, that's getting in the way of your judgment and your clarity of vision. Knock it off. That's one. Two, they answered the complaint. Their complaint about not being properly served is moot. Is he there, Randy?
Yeah, I'm here.
Okay.
Oh, it's Jeff.
This, your
he's probably there, but he's probably there. I just got it muted.
To draw or get blood, it's getting in your way. It's getting in the way of your clarity of vision. It's getting in the way of seeing things the way they are. Gotta knock it off, guy.
Okay, well, for one thing, I'm not trying to get blood in a personal sense. It's just a sport. I'm trying to go for the knockout in round one. It's just sport.
Well, people. Okay, so here's the thing. Have you ever hunted?
Fumble on the 1 yard line and go in for the touchdown and win the game.
Yeah, I understand, but here's the thing. Have you ever been hunting?
Not in a long time.
Okay, have you ever been warned about sometimes a person that doesn't have an orange hat on, standing amongst a bunch of lower growing trees, will look like a deer with antlers?
Okay, yeah, I've heard that.
Yeah, no, shoot.
A heifer with the big sign hanging over it that says, "Don't shoot me, I'm a cow."
Right.
Looks like a deer.
Remember, there's the old cliche, the old saw of revenge is best served cold. But you're hot. Knock it off.
Well,
I know you want it, but you're going to have to pick your time when the path is clear, the target is in the open, and you've got every opportunity to make your kill.
That's a nice general platitude. But what about using an aggressive stance in order to make it more difficult for opposing counsel to force you to deal with frivolous pleadings?
And that's what I'm doing.
Hang on a second.
Okay.
It's
like in a bullfight, when
you have these, you're a pro se, so you have powers and abilities beyond those of mortal attorneys.
Right.
Jeff, are you saying this will likely affect the way the judge rules in Jeff's case?
I don't know that it would necessarily affect the way he rules, but if he does something like this, it's definitely going to affect the way the judge sees him.
And if he
gets a bad taste in his mouth, that's disfavor. He may if it's kind of like throwing somebody goes in for a job and their credentials and their backgrounds are virtually identical, and the sole difference is the way the two of them came off during the interview. Well, guess who's going to get the job? The guy that came off in the interview the best. And the guy that put a bad taste in the interviewer's mouth, he's going to lose. So don't go there.
Wait a minute. This is not a job interview.
I know. I'm
using
metaphors in order to be able to people to be able to equate.
But it implies what I would consider an inappropriate perspective.
Well, maybe so.
The judge has a duty to determine the facts in accordance with rules of evidence and apply the law as it comes to him to the fact in the case. If he has himself another agenda, he needs to get himself down off that bench, or he needs to get my
now I know where Jeff gets it from. You pull your claws back in.
These judges have been ruling against us out of hand at every turn with absolutely no concern.
And our group is virtually 100%.
We're supposed to cater to them?
Our group is virtually 100% successful. Not quite 100%, but almost. So maybe it has to do with the approach that's taken.
Have you read my pleadings?
Yeah.
I don't go after judges. I don't go after the other side. And it makes no difference what I put in a pleading. None.
And you're in the Northern District of Texas, right?
Yeah.
Yeah. And the only way you're going to
I just had one in New York.
of Texas is on appeal. Because
I don't care if that judge is upset with me or not.
I know you don't.
If he's upset with me, he's likely to make a more stupid ruling because he's going to rule against me in either case.
That is a pure speculative statement.
I have to come to the table from that perspective, or I will fail to argue all of my issues.
Well, we have appeals that have been won, and we're pro se, and we have court cases that have been won, and we're pro se, and we have almost 100% track record. So maybe there's something that we're doing right that you might want to take a look at.
What could that be? Not objecting to wrongful behavior on the part of the other side? Could that be what it is?
No, we object. As a matter of fact, Guy, who was it that pointed out 37C to you last week?
I don't understand what you're telling Jeff to do.
I'm telling him to slow down on putting his hand on a sidearm and because it's coloring his judgment. He doesn't really know that because they answered the damn complaint, that the complaint about not being properly served is moot because he's too tied up with, I want to get sanctions.
You take that different.
If that point is moot, that's a chance for me to go in and put a tackle on somebody's legs and get them.
No, it's not.
Because if they're lying, then I am going to put that on the record.
No, that's a function of perception. It does what I'm saying to you is because they answered, their complaint is moot.
Yeah.
Not because they lied, not because they didn't get served, but because they answered.
It was obviously moot when they answered. And
right.
While you and I are pro se's, we can make these kind of mistakes. But if a lawyer does that, he does that deliberately for the purpose of forcing the pro se to answer a frivolous argument.
If the pro se is stupid and ignorant.
The Bar Association standards forbid the lawyer from doing that specifically.
And the court's not going to do anything about that.
Well, they certainly won't do anything about it if you just, what did Shakespeare call it, wink at their discords?
And say what, please?
If you just let them do whatever they want to without...
Did I say that? Did I say that? No, I didn't say that. It's an issue he can raise of their inappropriate response in their answer. Okay. And leave it at that. That does not stick his neck out in any way, shape, or form for the judge to develop any kind of disfavor or distaste for him.
Okay, I have a problem with that.
Well, more than likely you would.
Well, this perception, and it's a problem I have with people going into court. They're terrified that the judge might not like them or might get upset at them. If we don't fix that, we're not going to have fair and honest courts. Hang on. Randy Kelton, Rules Law Radio. Our call-in number, 512-646-1984. We'll be right back.
Forget the tanning booths, hours in the sun, and instant tan lotions. There's a much better way to boost your skin color, and it's really good for you. I'm Dr. Catherine Albrecht, and I'll be back in just a moment with a skin-sational tip.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Humans prefer a healthy glow, but not the kind from a beach or a bottle. This kind of glow comes from carotenoids. Carotenoids are red and yellow antioxidants found in foods like carrots, spinach, and pumpkins. Researchers say that people who eat lots of fruits and veggies have higher levels of carotenoids in their skin and a more yellow hue to their face, and people like it. Study participants were shown images of a face. The original one mimicked a suntan, and one mimicked carotenoid coloring. The carotenoid look was judged most healthy. So instead of basking in the sun, hit the salad bar. It's better for you, and you look healthier for it. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
Live Free Speech Radio, LogosRadioNetwork.com.
Mr. Officer, you're taking the law in your hand. Won't you follow the law of the land? I don't understand. Your job is to protect and to serve. not the other things. Not me, sir. When you gonna stop abuse your power? When you gonna stop abuse your power? When you gonna stop abuse your power? When you gonna stop abuse your power?
So, Jeff.
Okay, we are back. Randy Kelton, Real Law Radio, and this is blood on the floor from the break. It's been a terrible night. Okay, go ahead, Jeff.
Jeff, Randy says that I was unfair to you by having characterized you as being so anxious to get sanctions that you couldn't see the defect in their answer where their complaint about not being properly served was moot. And if you felt that I was unfair, I apologize. It wasn't intended to be that way.
Oh, it doesn't bother me. I sat for a year in a Mississippi penitentiary, and a judge put me there. So when I walked in the room, I bar grieved both attorneys about 20 times, and then I start questioning the judge about his being unfair. So everybody's red in the face. So I'm a very uncomfortable person to be in the courtroom with.
Okay, that's fine with me. So, but as I said, because they answered your complaint, their complaint about you not being properly served is moot.
It's moot. And
it's moot.
I'm going to run with that.
You know, come on, guy, get some bigger fish to fry.
Well, that's what we were suggesting. That while it was crappy and dumb of them to do that, that wasn't very important. Now, if they put in a filing that was absolutely, totally fabricated and slandered you and all kinds of other things, you might want to raise the issue. And no, I don't suggest that you ask for sanctions for something that's essentially frivolous, where your request for sanctions will be deemed as frivolous.
Or de minimis.
De minimis, yeah. Before you called, before you came on, Jeff, that's exactly what we were saying. What we suggested is this is not important enough to waste your time with.
Okay, so my answer to their answer is paragraph 1 is moot.
Yes. Now, wait a minute. What answer?
I'm answering their answer.
Why?
Just so I can have something on the record.
Why?
I don't know. Just so I can have.
And why? It's not.
Let me go to the point. You file a petition. They file an answer. Then you address it in court. Unless their answer is so insufficient as to be a non-answer, then you file a motion for default judgment.
Right.
But just to challenge their answer. But you don't really answer their answer. It always in court, somebody files a motion, somebody else files an answer, and the filer can respond to the answer if it's necessary. And then your response, if the other side doesn't like it, they can't answer that unless they go to the judge first and ask his permission. Because they don't want this back and forth, back and forth, back and forth. Whatever you have to state it. And be done with it. And the other side's going to state his position. He's not going to agree with you. But you don't have to go in and micro-examine every issue, because you'll do that in the process of the court. Does that make sense?
Yeah, and that's really nice, because I hate going to the post office every other day.
Okay.
Okay, I have some questions for you.
4 responses to these people, and it's driving me crazy.
Yeah. I have some questions for you, Jeff. Do you know if, according to your local court rules, if the judge sets up the 26F conference?
Yes, I've got it coming up on the 14th of April, in about 8 days.
You guess?
No, it is coming up on April 14th in, I guess, 7 days.
Has the judge sent you a schedule for review, or is he going to send you an order to conduct your 26F?
Yeah, he did send me an order for the 26F, and then it just says telephonic conference.
Okay, did he send you a copy of what his proposed 26F is?
No.
Okay, well,
did opposing counsel send you a proposed schedule order?
No.
Okay, here's the thing. In my particular jurisdiction, they will send you the judge will send you a proposed 26F, and you have to argue it.
Okay.
Usually, do you know what a 26F is?
That's the scheduling conference or the conference report. You have to come up with a report saying that you met with the opposing counsel and that you're going to get the discovery in 30 days and get all other electronic filing in 60 days. So it's like a timing schedule report.
Okay, now, are you committed to the 30 days and 60 days you just said?
It doesn't matter to me because I'm already done. So I don't care. But if you think best, I'll do.
Okay, so. Jeff, hold on. We're in the Fifth Circuit, and at least here in the Northern District, you have to. The parties must exchange proposed scheduling orders, and then they're to agree on a scheduling order and file that with the court. If they can't agree on the scheduling order, then both send a proposed scheduling order to the court, and the court will rule on what he wants to.
Okay, so here's what I would suggest you do, Jeff. You call up the clerk, not the judge's clerk, the clerk of the court, and find out how they conduct their 26F conferences that the judge has ordered, whether everything is supposed to be worked out during that conference or if everything is supposed to be worked out in advance of the conference and all the judge does is basically take dictation.
Got it.
And don't overlook your 26A1 disclosures.
Okay.
Do you know what the disclosures are?
No, I don't have 26A1 in front of me.
Okay. It's all the documents that they have in their custody or control and all the witnesses that they have in their custody or control that they intend to use at trial.
Okay.
Okay, it's not the same as corporate disclosures.
Mm-hmm.
Okay, like, if I'm General Electric and I have to list out all the various companies that I own so the judge knows whether or not he might have a conflict of interest because he owns 90% interest in some particular subsidiary that GE owns.
Mm-hmm.
That sort of thing. 26A1 disclosures are basically the documents that they intend to use and the witnesses that they tend to call.
Yeah, and they tend to have disclaimers saying these are all that I'm aware of at the moment.
Right. And that's not a disclaimer. That's a caveat.
Well, they protect themselves in case something else comes up there.
Oh, yeah.
So that these disclosures are not definitive and you're not strictly bound by them.
Okay.
I'll do that tomorrow.
Okay.
Okay, one more thing before you leave, Jeff. I've got Max who wanted to make a comment on your issue. Max?
Yes, sir.
You wanted to comment on Jeff's issue?
Yes, I did, and this has been a wonderful Thursday show so far, might I add.
You just like it because me and Jeff Sedgwick are fighting like cats and dogs.
Oh, I thought that might be blood. I was worried about that, guys. But you know what? It makes for great listening.
Okay, move the mic just below your mouth a little. Your mic's kind of distorting.
Okay, you know what? It's probably my booming voice.
Much better.
Okay. I had thought that Jeff in Maryland is correct for warning Jeff in Mississippi about getting too involved in the fight. In fact, Randy, I've heard you issue the same warning about knowing your intended outcome. So I thought that, Jeff has been aggrieved. He's been harmed here. So the Jeff in Mississippi, that is, has been harmed here. So it's up to his discretion as to how far he wants to take this. I hear the break music. You go ahead and give us an outro.
Okay, this is Randy Kelton, Rule of Law Radio. Our call-in number, 512-646-1984. And, this is a short break. When we go to the next break, make sure you go to Logos Radio Network and look over our sponsors. We need all the help we can get.
Easy.
Not wage any battle, would your purpose have to be done? Such a sentiment, a soldier, a warrior of love, scuffle and keep the peace.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Jeff in Mississippi. Max, I'll get back to you. We've got 2 or 3 more call-ins ahead of you. I wanted to pull you in for Jeff in Mississippi. Jeff, do we have anything else for you?
No, that's it.
Okay, have we beat you up enough?
That's great. And I'm a very assertive person, so I'm either going to go for a default judgment or summary judgment. I'm not sure which one you told me to go, that I could go for, but if these people are lying in an answer, I'm going to put the hurt on them. You just call me Hannibal Lecter.
Okay, Thank you, Hannibal. Okay, now we're going to go to Eric in California. Hello, Eric.
Hi, how are you doing?
I'm good. What do you have for us today?
Well, I am going to court on Monday for a traffic ticket, and this is in California. There's 2 violations on the ticket. One of them is speeding, and the other one is lack of insurance. I did actually have insurance at the time, but I didn't have current papers to show the cop.
Did you ask for a jury trial?
No, I did not at the time.
I'd love to do that when they give me a ticket for no insurance. I make them impanel the jury, go through all of that, let the prosecutor go through his whole spiel, and then I pull out my proof of insurance. The last time I tried that, the JP was ready for me and come out and dismiss the case. She said, Mr. Kelton, if you have insurance, just pay $10 and we'll dismiss the case. I'm not paying anything. I want a jury trial. She dismissed the case and told me to get out of here. Okay, go ahead. Speeding and no insurance.
Right. So the court date on Monday is for the arraignment, the first court appearance. And I'm wondering, how do I handle pleading? I know I've heard before you shouldn't enter into a plea.
All this stuff about not pleading is kind of it's the kind of thing Jeff complains about. Why? That's a worthless fight. I go in, and the only fight I have over entering a plea is I don't want to enter not guilty. I want to enter innocent as the driven snow. And they never want to accept that. So I wouldn't start a fight over something that doesn't matter. But a good challenge subject matter jurisdiction, that's something that's fun to do.
Right.
Have you listened to Eddie's Monday night show?
Yes, I have. Yeah. And I've seen some.
Like Max said earlier about always know what your intended ultimate outcome is. Now, everything you do, gauge that against, is this going to get me a dismissal? Because I'm assuming that's what your outcome is, unless you have a different one. Right. Some people just want to have a fight and learn the law by having a nice fight in traffic court. What do you want as an ultimate outcome in these 2 cases?
Well, I want to get the violations dismissed, the charges dismissed.
Okay. The insurance one, that's a foregone. Once you show the proof of insurance, that one will go away. You probably could have already got that one tossed just by bringing your proof of insurance down to them. And if you go in to the arraignment hearing and hand them the proof of insurance, they'll dismiss that one right off the bat. Okay. Now they have less leverage. But for the most part, if you go to the merits, then the judge has discretion to determine who he believes and who he doesn't believe, and he will almost always believe the officer because it's to his benefit to do so. They're there to generate revenue. So if you go to the merits, you're likely to lose. I'm not saying you always will. If the cop did something really stupid and you have a halfway honest judge, sometimes they'll actually dismiss. But you have a lot better shot going after the underlying law. And the judges seem to be getting sensitive to this right to travel issue. Do you have Eddie's right to travel pleadings?
I've seen that before. I know mentions the constitutional right to travel and the idea that a constitutional right cannot be turned into a privilege or, cannot be turned into a crime.
That's basically it. And what this goes to is subject matter jurisdiction. And that can be problematic for the court. And my position on traffic tickets and most of these lower court issues is you won't win your case simply because you have the law and the facts on your side. This is all politics. So how do you get political pressure to get the courts to drop the case? Now, we've got Scott from Dallas. He calls in on a regular basis. And he gets them to drop his case because they don't want to mess with him. He had an officer break his window out because he wouldn't roll his window down. He wanted a supervisor. And the officer broke his window out. Problem. Scott had his video camera in his pocket, put it on eBay, got 1.8 million hits. They couldn't get him out of their court fast enough. So the right to travel issue is a real annoyance for the courts. One of the cases, Scott went in and the judge said he started the right to travel issue, and the judge said it won't be any of that in this court, and shouted him down. So what do you do in that case? We go to the grand jury and file criminal charges against the judge. That's what Scott did. And all of the cases so far, except one that he's had, have been dropped. And he's filing on the judge in that one. In these lower courts, it's all about the money. You give them enough trouble, it costs them too much money to prosecute you. Good chance they'll dismiss the case just to get you to go in and give money. But it takes a lot of work. You have to do your homework. There's no way around it.
Right.
Yeah,
now, I noticed on the on the court website it has a docket history for the case, and I haven't entered into a plea. As I said, the appearance Monday is an arraignment, so I haven't entered into any plea yet. But it says on the website not guilty. Is there any significance to that?
No. They will assume not guilty unless you tell them otherwise. They're going to act. Okay. That's the only assumption they can have, because that's the only assumption that has no potential of harming you.
Right.
If you want to come in and correct that presumption, you're perfectly at liberty. Oh, yeah, I'm guilty of sin. But they're not going to do that. So, no, that won't have any significance.
Okay. Now, can I file motions in court during the arraignment as far as, challenge matter jurisdiction and stuff like that?
That is the only one. There's two. There's a pleading and a motion. There's a pleading you can file. Well, technically, subject matter jurisdiction is a pleading. You can file double jeopardy, and you can file subject matter. There's other pleadings, but they don't apply to a ticket. Subject matter can be filed at any time. And I really annoy these judges because I go in and file a 30-page challenge subject matter jurisdiction 20 minutes before trial. And I've had judges complain about that several times. Mr. Kessler, you just filed that 20 minutes ago. Yes, Your Honor. As a matter of fact, I did. But it is a challenge to subject matter jurisdiction, and it may be filed at any time, no matter how remote in history. Okay. So even if they rule against you, you can always file a challenge subject matter jurisdiction. But since your hearing is Monday, normally they want 7 days notice on a citation. So if you didn't file anything within that 7-day time period, you're kind of barred from doing it. It's not something that can be heard in this particular hearing because the prosecutor hasn't had time to examine the document and come up with a response. So, but this is only an arraignment. And it would be nice to have one and drop it on them. You don't expect them to hear it now. Well, you do ask them to hear it now, but what the judge can do is this. When you file a challenge subject matter jurisdiction, you come to the court at arm's length. In that, there's a lot of pro se stuff about not entering into the jurisdiction of the court. Well, this one is the real deal. When you file a subject matter jurisdiction challenge, you're not admitting to the jurisdiction of the court. That is Jeff, what's the term for that? The threshold issue. That has to be heard before anything else can be touched. So if they go to anything else and you have a subject matter jurisdiction challenge, that gives you a due process claim against them. Now you got something you can work with. So hang on, pick this up on the other side. Randy Kelton, Real Law Radio, here with our very special guest and 2 times radio show boxing champ, Jeff Sedgwick. We'll be right back.
Babylon, I'm born down the whole nation. But of them operate the land wrong. How many say Republican and them a scratch, man? Tell them I'm a libertarian. Them say we want to lose, but we want to win. Come round. Justice and peace. Child love rule this time. How what we say? Child for our wars.
Okay, we are back. Randy Kelton, Rule of Law Radio. And Eric, did you, other than subject matter jurisdiction, and I know you mentioned the right to travel.
Right.
It's my position that the best way to bring the right to travel issue is in a subject matter jurisdiction challenge. Because that's really where it goes. It says you don't have authority to interfere with me when I'm not in commerce. So what do you plan to do Monday?
Well, I want to either file a motion, or I don't know if I can do it verbally in front of the judge, but I want to file some kind of a motion doing just that, challenging the subject matter jurisdiction. So any advice you have on how to do that?
Oh, okay. Have you got Eddie's traffic seminar?
No, I haven't.
Okay, I have a challenge to subject matter jurisdiction for a traffic issue, but it's written to Texas law. It won't be of much value in California. You might get out to, if you'll send me an email, randy@rootoflawradio.com, I'll send you my challenge subject matter jurisdiction. The subject matter jurisdiction section is valid. The traffic code section is not valid because that goes strictly to Texas law. You need to get the transportation code for the state of California and see if you can cross-reference the citations that are in this, the Texas citations I have in this document.
Okay.
There's probably somebody out there who's done that, but since it's Monday, Monday's not a really big deal. What's going to happen is they actually force you to come down there so that the prosecutor can try to make a deal with you.
Okay.
So you don't have to have anything in. You go in there, then they'll set a court date, and now you have time to file a motion. So I would suggest you just go down there and plead not guilty. If you want to get rid of the insurance one, just hand them the proof of insurance. That one will go away. And then set a jury trial for the other one. That's going to annoy them because now they got to pay a jury. And then you have time to go to Eddie's show and see if someone who's one of his listeners has a challenge subject matter jurisdiction for California.
Okay. You don't think there's any problem with pleading not guilty? I mean, doesn't that mean I'm agreeing to their jurisdiction?
No, that doesn't agree to their. Okay, here's the deal. Let's say you don't like the judge down there. So I tell you what, Eric, why don't you just let me be the judge? We'll have this trial and I'll be the judge for you. Tell me, what can you do that would give me jurisdiction to rule in that case?
Nothing, I guess.
Exactly. There's not anything you can do to give this judge jurisdiction if you don't have it.
Right.
There's a lot of huffing and puffing about that, but if he don't, we're talking subject matter. If he don't have it, he can't get it. You can't give it to him, period. So you don't have to worry about that. You've agreed to make an appearance, make the appearance, plead not guilty. It won't harm you in any way. Doesn't agree to anything. And part of your not guilty is not guilty by way of lack of subject matter jurisdiction. But you just plead not guilty. It's not the place to start the fight. Get the insurance ticket tossed, and all you have to deal with is the traffic. They have less leverage. They don't have as much money to make on you, so the fight relatively costs them more. So then get on Eddie's show. He's the traffic guy, and I try to stay out of his area. And see if someone on the show is from California, and I'm sure there are. There's a number of people from California. You can probably get one already structured for you. Just sign it and send it. Okay?
Okay. Okay. Another question. Is there any need for me to say that I'm there by special appearance? I've heard some mention of that before.
No. You only do that when you file the subject matter jurisdiction challenge.
Okay.
You're here at arm's length to the court. This is saying I'm not here to agree to the jurisdiction of the court. I'm here to challenge the subject matter jurisdiction of the court. But that is never necessary anyway. You don't have to say any of those. There's no magic incantations here. You just file the subject matter jurisdiction, and it's before the court. Doesn't matter what you say. Okay. Good luck.
So you're telling me to plead not guilty and then file a motion after that?
Yes.
Yeah.
Yes, but pleading not guilty doesn't affect the jurisdiction in any way.
Okay.
Okay.
All right. Well, thank you very much. I appreciate it.
Thank you, Eric. Okay, now we're going to go to Gary in Texas. Hello, Gary.
Hey, Randy. What's up, my friend?
Oh, been a long time.
I know it. Hey, I've got an easy question for you. I'm helping somebody who got arrested, a criminal offense in another county, and filed a few Public Information Act requests, and when they weren't timely answered, I sent a notice to the Texas Attorney General to ask for intervention, and the AG came back and ordered them to supply the documents that had been requested originally. So anyway, the attorney that's involved with the accused spoke to the prosecuting attorney and said, you really got a problem with this case, so I really think you ought to just dismiss it because the videos are really, really not good. They're not in your favor. And they said, there is no way that we're going to dismiss this case. I'm taking it all the way because I'm so angry at all of those Public Information Act requests. I want to make him pay a price. And I thought, that to me, that sounds like
3606, 3605 Penal Code.
Yeah.
Witness tampering. It's obstruction of justice. That's the way I read it.
How about official misconduct?
Official misconduct. Texas is the only state that I know of that has two separate designations. Official misconduct in Texas applies to someone misappropriating public funds or government equipment. Official oppression goes to misfeasance or malfeasance in office. Mm-hmm. So there's one other place where there is a official misconduct statute, and you have that available, and that is the 552 Government Code, the Open Records Act. And in that one, that is the one place where the Attorney General is given original jurisdiction. When you file a complaint under open records accusing the district or county attorney of violating the act, that is filed with the Attorney General directly. So I suggest you file a criminal accusation against the district attorney with the Attorney General. That should get interesting. And then also attach to that an associated accusation of witness tampering and obstruction of justice. Obstruction of justice is also the retaliation statute.
Okay, I don't understand the witness tampering. Can you elaborate on that a little bit?
Because the defendant took legal action in order to secure evidence that he could use in court, that the prosecutor retaliated against him in order to prevent him from using that evidence in court. That's how I get there.
That's interesting.
Let him dance with that. Let him explain that to a grand jury.
Does abuse of authority fall in this plethora of complaints?
That's 39.03. If a public official acting under the color or meaning pretense of an official capacity fails to perform a duty he's required to perform, or exerts or purports to exert an authority he does not expressly have, that's official oppression, class A misdemeanor.
Okay. Now, Texas Code of Criminal Procedure, Chapter 2, talks about duties of a prosecuting attorney and about seeking justice and not to seek a conviction. Does any of this...
2.01, it shall be the duty of the prosecuting attorney not to secure conviction, but to ensure that justice is served. He shall not secret evidence or witnesses that may show the innocence of the accused or mitigate the guilt of the accused. That's exactly the way it used to read. They've changed it up. It doesn't read exactly like that anymore, but that's a paraphrase. It goes to exactly that thing. However,
now I don't. Okay, go ahead.
It does not give the prosecutor a specific duty, so it's not very useful. It's just kind of high-minded rhetoric.
Okay, yeah. I was about to say I don't read any type of penalty associated with that declaration in Chapter 2.
Well, did have a duty to release all of the evidence that he had. And but he had that duty under the Open Records Act as well.
Mm-hmm.
He has it under the Code of Criminal Procedure. He also has it under the Open Records Act. Anything that doesn't fall under his work product, anything that's not considered secret, that not everything that the prosecutor has is open records. But if you are a litigant, then there are things that would normally not be open records that you would have access to.
Okay.
And that's what he failed to give. So,
what about bar grievances, Randy?
Oh, absolutely. Is the prosecutor who did this the elected prosecutor, or is he an ADA, an assistant?
Elected.
Oh, good. If he gets unelected, he's going to have a problem getting himself malpractice insurance. Hang on, Randy Kelton, Rule of Law Radio, here with Deborah Stevens. We'll be right back.
This is the Logos Radio Network.
Ain't gonna blind me. Don't bore me. Well, ain't gonna fool me with that same old trick again. I was blindsided, but now I can see your plan. You put the fear in my pocket.
Okay, we are back. Randy Kelton, Rule of Law Radio. And we're talking to Gary in Texas. Okay, Gary. I like the witness tampering. Okay, it's not so much about what actually happened. It's about what kind of really cool story you can create about what happened. You request this information under open records, and the prosecutor don't want to give it to you, and you have to get the Attorney General to force you to. And then when you get it, it turns out to be exculpatory evidence.
Correct.
So you can say he violated Article 2.01 by failing to provide exculpatory evidence. And he will say, well, I did provide it. I said, yeah, but you didn't provide it when you were required to. Like I went to Weatherford County, to Parker County, Texas today, and I brought some information requests and gave them to the receptionist, and then they sent these to, is it appropriate for me to say big, fat, sloppy-looking lieutenants? No, that's not appropriate, so I won't say that. They sent these two lieutenants out, and I asked them a couple of questions that were very pointed, and they decided not to answer my questions. So I said, is there any question I can ask you that you will answer? And they said, no. Then why am I talking to you? You can go. You're dismissed. And one of them said, and what's your name? My name is you are dismissed. You can go. They ordered me to leave the jail, and the receptionist refused to take my information requests. Now, I went to the sheriff and filed criminal charges. Now, if they respond to my information requests, sorry, Bubba, that bell has already been rung.
Correct, right.
They can respond to it later. But when they refused it then, they rung that bell and they can't unring it. And the prosecutor refused to provide exculpatory evidence. The bell was rung. They can't say that you ran the stop sign. You say, okay, I'll come back and I won't run it this time. So, the allegation should be, since there was exculpatory evidence in there, that implies that he was deliberately attempting to hide that evidence. What is that? Hold on. Secreting evidence. These are government documents. 3710 Penal Code. If you secret a government document from the person or office it's intended for, that's tampering. You might try tampering with a government document. And then
that's good.
Violating 552 Government Code, violating 127, I think it is, Code of Criminal Procedures, either 127 or 129, that says all courts shall be public. In court issues, the Open Records Act does not apply. 1.27, the statutory version of the constitutional right to a public court applies. So when you go to the court and ask for records, and they ask me what law I'm asking for this under, and I tell them any law that applies. You want legal advice? Go to the prosecutor. If I say under the Open Records Act, they say, the Open Records Act doesn't apply here. So I just tell them whatever applies. 1.27 applies. So if he fails to produce it, that's official oppression by misfeasance in office, failing to perform the duties required to perform. And if he does it for the purpose of denying you access to exculpatory evidence, that's obstruction of justice, 3606. And if you take some other action in retaliation for your exercising a right, that's retaliation, also 3606. And if he does this to prevent you from testifying, it's 3605.
Now,
sound like fun, Gary?
Yeah, it does. And see, I want to grab hold of this retaliation against the accused, because the prosecutor,
that is probably the best one. Yeah.
Yeah, the prosecutor said definitely. Oh no, we're going to take this all the way because he made me mad because he asked all those questions with the Public Information Act request, and I'm going to basically saying I'm going to teach him a lesson. I'm going to make him an example, and that is clearly retaliation. And the prosecuting attorney told an officer of the court that that's what they're going to do.
That the legal specification for that is an oops.
Yeah.
Never interfere with someone when they're screwing up. We had a woman who was was in court over a home equity note on eviction. So that goes to the district court. And she filed a challenge to subject matter jurisdiction of the court. Now, what her claim is that the plaintiff lacked capacity to invoke the subject matter jurisdiction of the court. But the judge gets it, and he says, normally these lawyers don't like me because normally I try to help borrowers to prevent eviction. But since you challenged my jurisdiction, I'm going to rule against you. What? You did that in open court? Duh. Excuse me. So that was a good thing. If we can get them to do something really stupid, wonderful. And you've got almost precisely the same thing. Odd how these things come in groups. So, does the person who is accused file the complaint? Or do you file it, Gary?
I think anybody can file it.
Absolutely.
If you're made aware that a crime has been committed, anybody can file it.
Heck, you have a duty.
That's right. You're actually commanded to under statute.
And what I've been doing is taking my complaints directly to the grand jury, to the grand jury bailiff. And I'm about to take another set to Tarrant County because what they're doing is they're pretending to take them and then they're giving them to the prosecuting attorney. So what I'm going to do is give a set of complaints to the bailiff and then wait 2 or 3 months until this grand jury is out of session. Come back and look at the minutes of the grand jury. And when I don't find a true bill, I'm going to file criminal charges against the bailiff. Accuse him of shielding from prosecution by secreting these complaints from the foreman. And what the defense the bailiff will have is good faith reliance on competent authority. Well, the prosecuting attorney told me to do this, that, or the other. When the prosecuting attorney directs the bailiff, he's not a prosecuting attorney, he's a lawyer.
That's right.
Giving legal advice. No immunity. 0. So my plan is to sue the prosecuting attorney for giving the bailiff. Now, I'll sue them both and force them to stop interceding between us and the grand jury.
Yeah.
Hang on, Gary. Pick this up on the other side. Randy Kelton, Deborah Stevens, Rule of Law Radio. Our call-in number, 512-646-1984. We'll be right back.
You've heard of hairspray, but how about DNA spray? It's a high-tech way to catch robbers, but down the road, it could be abused. I'm Dr. Catherine Albrecht, and I'll be back in a moment with what you need to know about aerosol microdots.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Exploding ink can cover thieves in a profusion of purple, but nowadays they need to look out for spray-on polka dots the size of pinheads, too. The Selectamark security system uses DNA spray on robbers as they make a getaway. The coating glows under ultraviolet light for weeks, and police can identify the crime scene because the spray contains unique microdots. While it's currently used to nab criminals, the spray could be turned to other purposes. Imagine attending a political rally and later glowing under ultraviolet light at the airport. It could give a whole new meaning to the no-fly list. Maybe we should all be wary of DNA spray. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
Chemtrails. You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Yeah, who you want to chip? Who you take me for? Free toilet? Who you want chip? Me no free toilet. You can't chip me. All I'm saying. Don't let them chip you in the morning, chip you in the evening, put a chip in your body. And then
Okay, we are back. Randy Kelton, Rule of Law Radio. It looks like we lost Gary over the break. So we're going to go to Ralph in Texas. Hello, Ralph. What do you have for us today?
Hello, Randy. How are you?
I am good. I don't care what everybody says.
Yeah, you sounded pretty good earlier talking to Jeff.
Well, Jeff beat me up over the break. There's still blood all over the studio.
Well, I was surprised to hear him talk like that, but he did say he was doing some good up there in Maryland. So, you know.
Jeff, they are really doing well up there.
Well, is he still there? Because I wanted to get you and him both discussing in agreement my question. Is Jeff still there?
Go ahead.
Okay. I heard on your show last week, I believe, that common law is case law. Is that correct?
That is correct. That's the only common law we have now. Prior to the statutory codes, they impaneled judges or elected judges and expected those judges to dispense common sense law. So the law essentially was what the judge believed was fair and equitable. And then when we put in statutory law, the only remnant of common law was the way that the judges interpreted the intent of the statutory law. So yes, the only common law existing now that I can find after years of looking is case law.
Right, and that's what all of our laws are today, unless it's something like Admiralty Maritime or...
Well, the maritime really doesn't exist. Well, it exists, but not by itself. In 1965, maritime law was merged with federal civil law. So if you go look for maritime law, you won't find it. You'll find it in the civil code.
So federal civil lawsuits would be considered common law, a.k.a. case law.
Well, no, they would be statutory law.
Okay.
There's no court system that we have that doesn't act under the dictates of a statutory code. And I once did a presentment to the Republic of Texas, and they're advocating the common law. And I addressed that with them. Are you kidding me? Right now, you can't get judges to enforce a very strict statutory code. And you want to take away that code and let judges rule any way they want to? I don't like that idea. I want a very strict statutory code I can hold a judge to. I was just in Weatherford, Parker County, Texas. And this is a case on the right to travel, and this judge is doing everything he can to stamp that out. I have a motion in limine filed by the prosecuting attorney that asks the judge to forbid the defendant from bringing up anything related to the right to travel. And the judge has granted that. Now I'm going to go to a grand jury and ask a grand jury to indict that judge for granting that, because it flies in the face of Constitution and statutory law. If we were in the common law, I couldn't do this. I'm stuck with whatever the judge says. So I'm not much in one for common law.
Okay. It makes sense to me. I early on, years ago, I heard that case law was not good because it just lets the judge, tweak the law the way he wants to. And then other judges come by and say, okay, well, I'm going to use that, and then I'm going to tweak it a little bit. And so before long, the law is just what anybody says it is.
Okay, well, it's not quite that simple. And we have a lot of people making those complaints, but those are generally the ones that haven't researched the law closely. A trial judge, the only purpose of the trial court is to set the record for appeal. It doesn't make any difference. At the end of the day, it doesn't matter what the judge rules. What matters is that you get the facts and the law on the record, because when you get it to the appeals court, they live in a whole different world than the trial judge does. The appeals court makes these rulings, and once this ruling is made, all of these shyster lawyers out here can take these rulings and run with them. So if the appeals court issues bad law, then they undermine the corpus juris, the body of law. A trial judge can rule against you because he got paid, or he went out and played golf with the other attorney, and the other attorney lost $500 to him in a golf game. The judge come in and rule against you. Well, in the end, you don't care. And the dumber his ruling is, the better. The more likely the Court of Appeals is to overturn it. So we used to have a lot of people making these complaints, and that's because they didn't understand that the trial court is not that important. The appeals court is what's important. And because they live in this other house, they're responsible for the corpus juris. So when they issue a ruling, everybody starts using it, and you'll find where they come back and change a ruling. They issued this ruling, and they find that lawyers used it in a way they didn't anticipate. So they got to come back and fix it. We really do have a good system. And the problems we're having in the lower courts is that you and I are not taking these judges to task. Thus my difference with Jeff at the beginning. He's apparently having a whole lot better luck than me because I'm not winning 100% of my cases. And I've had a lot of lawyers look at my pleadings. They like my work. And I really struggle to get well-crafted documents, but the judges just don't care in the lower courts. I just had a ruling out of New York, and the issues they didn't want to look at, they just ignored. Didn't respond to them at all. So I'm filing against the judge for official oppression. He denied me in my right to petition the court for redress of grievance. Well, actually, not me. This was someone else I'm helping. But he denied this guy in his right to petition the court for redress of grievance because he didn't hear the issue that he brought before the court. And most of the time, lawyers don't take that on. And that's because lawyers are dangling before that judge by their bar card. I'm not. So I don't have to put up with this nonsense. So if you don't want to do your job, just get on off that bench and we'll have you replaced by somebody who will. You don't like me? I don't care. You just determine the facts in accordance with the rules of evidence, apply the law as comes to you, the facts in the case. You fail to do that, then you as the servant are subject to me as the master. That's what I see as the real problem. And it don't make any difference how we change laws. If you and I, the individuals, don't start policing our public officials, it won't make any difference what the law is. So, back to you. I think you had a more specific question. I've been kind of going over really general stuff.
Okay. Well, throw a couple of things out here. Paraphrasing a quote no law shall be written that the common man cannot understand.
Right. It goes to the reasonable person of ordinary prudence standard. Okay?
Okay, now, I read this in a civil complaint. It was item number 17, which is irrelevant, really. It says, plaintiff required the services of an attorney to bring this action and is obligated to compensate his attorney reasonably. Now, I have a problem with that because
what is reasonable?
Novelty.
Wait. Hang on. We're about to go to break. This is Randy Kelton, Deborah Stevens, Rule of Law Radio. Won't give out the call number. This is the last segment. But make sure you go to our sponsors and help us support this radio network. We'll be right back.
Easy.
Hello? Oh, man, in jail?
Okay, we are back. Randy Kelton, Rule of Law Radio. We're talking to Ralph in Texas. Okay, go ahead, Ralph.
Well, what I'm trying to figure out is how to put what I believe is a novel argument into a civil lawsuit. I cannot find references on the Internet as of yet, and I have spent some time trying to find any reference to pro se compensation. Attorneys are paid for, clients are paid, reimbursed for their attorneys, just like this article I just read. Plaintiff required the services of an attorney to bring this action and is obligated to compensate his attorney reasonably. So those are attorney's fees. But if ignorance of the law is no excuse for violating it, and no law shall be written that the common man cannot understand, why is it that people who freely choose to go to work, make a bunch of money, give some of that to the attorney, and then get reimbursed, and whenever they get paid, attorneys get paid, they're getting paid so much money that it covers their paper, their ink, their printers, their copiers, their Internet connection, their books, whereas a pro se goes in, he gets cost. He doesn't get, hey, I had to buy a small package of paper clips. Forget it. You can't get it. Pro se is only getting his fees and costs. So this really, it's been...
Okay, let me address that. Ordinarily, it wasn't intended that litigants be reimbursed for their cost of litigating a case. And then we get lawyers that help people litigate case. Now, you don't have to hire a lawyer. So you can litigate the case yourself. But if you choose to hire a lawyer, the legislature put in a special authorization for the courts to allow for fees to that hired counsel. There was no provision for allowing a litigant to collect fees for litigating his own case. And the courts have consistently held that.
Well, okay, hold on. Can you hear me?
Yes.
What if we change that word from fees to time compensated?
That would, restate the code with that adjustment in it.
Well, I don't have the code. I need to find it.
Okay, then. That would make it so that whoever loses the case pays for the whole case. And that is problematic from my perspective because nobody's ever 100% guilty. And it would have a strong detrimental effect on an ordinary person's ability to fight these cases. Because if you don't have the personal funds to keep up with the other guy, then these guys with deep pockets, they can hire lawyers and drive you in the dirt. And we have this now where they can hire lawyers and just beat you by attrition. This is what the banks do. If we allow not only the lawyer to be paid, but the litigant to be paid, it would be much easier for them to swallow us.
Sorry, I don't see it. I thought that's what was happening now.
It is happening now. They're doing that now, but I'm afraid that if we made it so that the litigant could claim his cost for litigating the case as well as his lawyer's cost, it would only exacerbate the problem. The thing that would fix the problem is if they couldn't get attorney fees.
Well, yeah, but
yeah, that wouldn't fix it either, really.
That sounds like a pretty big goal there.
Yeah. For the most part, if you're a pro se litigant, the other side doesn't get fees from you. We almost never have the court allow fees against a pro se litigant.
Okay, I was not thinking of that.
I mean, it can happen, and I'm sure it has, but we have never run into it. They always ask for it, but they don't get it.
Well, that just threw the biggest wrench in my argument right there. I am going to still consider how to put this in the wherefore clause of an argument to be compensated for my time. And for them to compensate attorneys is just sanctioning a...
maybe I misunderstood. I think maybe I understand your position better. You're saying don't compensate the attorneys, compensate the litigants. And if the litigant wants to hire an attorney, he takes it out of his compensation. Instead of him keeping the compensation, he gives it to the lawyer. Is that where you're going?
No, but that sounds better than where I was going.
Yeah, so if I'm a litigant now and I win, I have a right to get the time that I spent defending this.
Well, so you're taking my argument and just tweaking it a little bit to all litigants instead of pro se litigants, and I like it better. But what I had started with was if clients can be reimbursed for the money they spend on their attorney, why can't pro se be reimbursed? They're going to spend twice the amount of time that an experienced lawyer will, and they're going to, in many cases, they achieve the same, if not better, results. The ABA in 2007 or 2008 said that over 50% of all court-appointed attorneys were incompetent. So
I think it's way over 50%.
Well, I heard that on NPR News. I haven't been able to get a copy of it in the archives, but I do remember hearing that.
And in the lawyer's defense, they are incompetent because they're forced to be by the judges. They're afraid to adequately adjudicate your case, afraid those judges will kick their behinds.
That's what.
Anyway, that's a different issue.
But that's what they get for having a bar card, huh?
Yeah. You just can't get a lawyer who will actively adjudicate your case if there's any chance it may annoy the judge. Because when your case is gone, he's going to be back before this judge with another client. And the lawyer's in business. He's not Perry Mason. He's not independently wealthy. He has to make money. And if the judge will rule against his next client to get back at him over this client, he's not going to actively adjudicate your issue, not near as aggressively as you would yourself.
Randy, what if I put this in my wherefore clause that I want to be compensated for my time spent, and I use, say, about 300 words, a couple of big paragraphs, and it goes into, things like no law shall be written if common man cannot understand, ignorance of the law is no excuse, and there is no one required to hire a attorney. It's done by free choice. What would you think of that? Just imagine it written best possible light. I'm not going to try to read all of it right now, but what would you think of that? I mean, we were talking on it, we were touching on it. Can you kind of recap? What do you think they would do with it? Do you think it's a silly idea? Go ahead and give me your opinion on it.
The problem with that is we're graduating 40,000 lawyers a year. We've got way more lawyers than are needed. Per capita, we have, I forget how many magnitudes of times more lawyers than any other country. And you're going to have all of those lawyers rising up in arms to prevent any legislation of that nature. That's going to be a large hill to get over.
Okay.
These lawyers have a fit at any time you do. Their lawyers are trying to get it so that no private citizen can adjudicate their own case. They're struggling to get that. They're just bumping up against the Constitution. but they're doing everything they can to get there anyway.
Well, would that fall into a Supreme Court challenge, constitutional Supreme Court challenge? Hey, if these people can be reimbursed for their attorney, why can't I be reimbursed for my time?
Randy, can I jump in here, Randy?
Absolutely.
Yeah, I just want to make a quick comment. Yeah, we should be able to be compensated for our time as pro se litigants, but here's why it's never going to fly, besides the political reasons that Randy's saying that the lawyers run the legislature and they're not going to allow it. It's because when there's compensation for attorney's fees, that's considered damages. Okay, that's considered an out-of-pocket expense that you're being reimbursed for. And if it's your own time, that's not damages because you're not out any Federal Reserve notes. And the reason they're not going to compensate you for your time is because you're not licensed to practice law, and so you're not allowed to bill for your time. Now, maybe if you had some kind of paralegal certification, maybe you could bill paralegal fees, but probably not. It's because you can't bill for your time for legal services. If you could bill for your time for legal services under a license, then they would let you do it. But just some random person, I mean, what's the standard? What are you going to bill? I mean, $500 an hour, $10 an hour? There's no standard. There's no profession like that. So that's why it's never going to happen. Okay?
Really, really good point. I hadn't considered that.
Okay, listen, folks, we are out of time. Randy, bring us out.
Okay, Randy Kelton, Deborah Stevens, Rule of Law Radio. We'll be back tomorrow night on our 4-hour info marathon. Goodbye.